right. Can we all agree that that is true?
Absolutely.
Yes.
Yes.
All right. So now, Mikey, what does the rest of it say?
They got to conduct an investigation with. Oh, you want to do 3?
Yeah, man. So now we go to the 3.
Okay. Complete such person's investigation of the dispute and report the results of the investigation to the consumer before the expiration of the period under section 1681 IA1A of this title, within which a consumer reporting agency would be required to complete its action if the consumer had elected to dispute the information under that section.
Okay. So much to unpack here. So much to unpack. So let's do it, because what? We are trained to see things other people can't see. And when you see the things other people don't see, you can have the things other people can't have. Like the answers, right? So complete such person's investigation of the dispute and report the results of the investigation to the consumer. Does it say they should send the investigation back to TransUnion, Equifax, Experian?
No.
Who should they send it to?
The consumer.
What if you never got it?
They violated that law.
Y'all never
They
thought
violated the
about
law.
that part, huh? Y'all never thought about that part.
So wait a minute.
But Durian, you
So
can't
the
sue.
so
You can't sue the debt. You can't sue the furniture though.
Mhm.
From
Really?
huh?
Mhm.
Really?
I thought you
Don't
gotta
say
go
that.
through the
Don't
yeah,
say
he
that.
testing your gangster.
Don't say that.
I
Really?
thought you got to dispute through the CRA to the furniture.
So
No.
when we have the case law, Johnson versus Bank of America.
Mhm.
Oh, that's what Johnson did.
Oh, didn't Johnson sue Bank of America?
Straight to bank. Oh, okay.
Oh, interesting. When we have a Johnson versus LV&V or a Hinkle versus Midland, isn't that a consumer suing a furnisher?
Oh, okay.
Mm.
When we have a Bursaw versus Northland. All right.
He missed the first part.
So Durian,
Mikey,
so you dispute right to the furniture.
you
I just
can
sue the furniture
dispute
without going to the CRA.
directly with the furnisher and the CRA.
Right, that's what I'm saying.
This
You gotta
is
involve the
why I always say separate your disputes.
Right.
Because what's better than one lawsuit? 4.
Oh, okay.
I get paid 4 times.
I know
So
that's right.
Durain, that means so you send the cease and desist. If you send the cease and desist, you send it directly to the creditor, right? To the furnisher, right?
That's one place to send it.
Where would you what form would you send to the you would have to modify that to send when you send that through the CRAs, right?
But if you're sending a cease and desist, it got to be a debt collector. It can't just be a creditor. And the cease and desist falls under the FDCPA.
No, yes.
You can
The creditor
you can send a cease and desist straight to the bank.
but the bank is the creditor.
Right, but the cease and desist is under the FDCPA though.
A cease and desist is a cease and desist.
Cease and desist is under the FDCPA.
Right.
So what conditions must be met for a cease and desist to be applicable to a bank? A bank that is in collection of its own debts.
Right. So it got to be collection.
Yes, but it doesn't change the fact that you can still do it. There's just conditions that must be met. And the condition that must be met, the bank must be in pursuit of collection of a debt.
Oh, yeah.
Therefore, the
Right.
bank is acting now
Right.
as a debt collector.
Right.
So if they have their own in-house collection agency.
Like who?
I'm saying-
American Express. American Express has their own collection agency. Hmm.
Right.
All right, this is getting so deep, huh?
Mm.
Like, Dwayne, I never even knew a cease and desist could be that deep. You best believe it. Give me some Don Julio, I'll show you. All right.
Okay.
So now we established that they have a duty, an obligation to respond within what? 30 days, because what? They have to be, excuse me, the investigation of the dispute and report of results. So it's not just the investigation. They must report the results. So investigation and reporting must be done, right? It must be done before the expiration of the period under 1681 IA1A. The only expiration period under IA1A is a 30-day reinvestigation period. So it means that a furnisher is held to the same timeline and they must complete their investigation in 30 days. Their investigation and reporting the results. And if they don't or cannot do it, what else in IA1A stands absolute? I5.
Yep.
And if they cannot provide the information that's required, they have to delete it. And if they don't, that means now they have completely violated their 1681 S2 8E3 requirement, 1681 IA1A requirement, 1681
I5.
I5 requirement,
Yeah.
1681 S2A requirement, 1681 S2B requirement,
Yep. Yep.
all by not responding. I bet y'all didn't know there were so many consequences to a debt collector not responding, huh?
Oh man, you just opened my eyes up even more.
Hey,
It's right,
Doreen, I
it
just
is
went through
right
this.
there.
I just went through this, Doreen, and I won 2 cases already.
Who's that?
It's Ricardo.
Oh,
Oh,
Tell us a little bit of what happened.
So what happened was that
They'd be thinking the rain's just here enjoying some Don Julio, making some stuff up. Let's go.
so what happened was that I didn't even know about the debt until the lawyer sent me a letter saying that they're suing me. So I'm like, all right. So as soon as they sent that, I said, all right, I need a validation. I sent a validation letter with all this stuff. 30 days passed, they didn't respond. I said, okay. I said, all right, we just gonna go to court. So we go to court. The lawyer tried to lie and said, well, I never got the letter. I said, Your Honor, here's a certified mail saying that they got it signed by the secretary, right?
Hold on. The lawyer is saying that they never got the letter.
Yep. I sent a certified mail and I had the receipt. I brought all the receipts to the court and I told the judge, look, right here, it shows that their secretary signed it. And it shows, so the judge asked the lawyer, what do you say about that? He's like, I don't know what he's talking about, right? So I'm like, the judge said, well, it's here written that that you received it. So the judge said, I'll tell you what. So the judge says, so what do you want to do? I said, I want to dismiss the case. The judge says, well, Wisconsin is a little bit different. So they told the lawyer, all right, how about you guys go to arbitration? I said, fine, let's go to arbitration. I'm good. So then we go to arbitration. They try to bring up all this stuff. They asked me, do you owe the debt? I said, no, I don't. And I said, well, I got proof here that they said it. Then they brought up all this stuff. I'm like, wait a minute, hold on. When you were in court the first time, you say you never received the letter, but now at arbitration, you're saying that you received the letter. I said, so which one is it? Did you receive it or did you not receive it? And then they were like, well, we did, and we have information here that shows that you owe the debt. I said, well, show me. You haven't shown me anything yet. So at the end of the day, we couldn't resolve anything. So we went in front of the judge and let you resolve. I said, no, we're going to trial. So I'm like, okay, cool. So then they sent me this long letter, Doreen, saying, oh, they responded, they validated everything. And then they sent this long letter saying to the court saying they want to dismiss the case against me. Oh, they want a judgment against me because they said I never responded to the original letter in 30 days. I said, what? I said, wait a minute, hold up. I said, first of all, I never received anything from the original creditor. They had a signed affidavit. I said, that don't mean nothing to me. I said, because you can't prove, is there anything certified that showed I got it? No. I said, you can't prove I ever received it. So your lie about the 30 days, you can't prove that I even received it. However, when I received the lawsuit from you, within 30 days, I responded right away. Right? So, so that's the answer I gave to them, right? So we go to court, right, to trial. We go in front of the judge, and the judge is like, is there anything you want to talk about? So I go outside with the creditor. I said, hey, as a matter of fact, I found another loophole, Darain, that creditor had used a previous collector, and I had a cease and desist, and they continued to call me, right? So even though it wasn't the original creditor, it was someone that they hired. So I bring all
So
these,
it was an assignment.
yes.
It
So
wasn't a purchase of the debt.
Correct. So I brought all these emails to court, and I showed the lawyer. Their lawyer said, hey, so either we drop this case, or I got 14 emails showing that the previous person that doesn't mean anything to me. I said, okay, let's go to court. So we go inside, and the judge says, so first of all, the judge got on the lawyer and says, first of all, I cannot drop a case just because you said dismiss. He said, I have to prove that there's a case, right? And so he was kind of lecturing them, and he said, for me to have a case, the defendant has to say he doesn't owe the case. So he said, owe the debt. He said, so the judge said, so Mr. Christian, do you owe the debt? No, I don't. But he says, all right, so now we got a case. So come back and we'll file the case. So in the meantime, I sent him a countersuit, right? I countersued him, right? And just today I got a letter saying, just to let you know, we want to dismiss the case with no prejudice on both sides, and we're sorry we put you through this, and you have to pay nothing. I signed it and I sent it off. I said, this is the second time the same lawyer tried to go after me, and I beat him twice. So the second time they had a vendetta against me, and I still beat him again. I didn't play games with them, man.
Bro, I would just go after them now for the fun of it. I swear to God. Because you have more than enough to go back after them for fraud.
I can, but so check this out. They messed up and showed me what they bought the debt for, right? I said, so the debt was for $6,000. They bought it for $571. I said, so time is on my side, right? So now I'm saying, the more I drag this out, the lawyer fees are going to cost them more than what they pay for the debt. So that's exactly what I think happened here. They were like, you know what?
It's not worth it.
I'm spending too much money.
Because if you even elect now to go to arbitration alone is a few $1,000s, at least $5,000.
And I pushed them through it. Nope, no agreement. So
is it really worth collecting $500 to spend $10,000 to collect $500? In what universe does that make sense?
So I think that's what eventually they said, you know what? I think the original creditor eventually said, you know what? This is dropping. This is costing me too much money.
You know what? Let's leave this dude alone, man. It's not worth it.
So I just want to tell these guys here, they try to scare you with lawsuit. Don't even be scared. Just go through it, because eventually they're going to drop it, because they're going to see that, hey, man, this dude know his stuff, right? So I told him, the last letter I sent, I said, look, I'm going to sue you. And as soon as I hit the countersuit, all of a sudden things started to change. Wait a minute. Hey, let's think about this. So let's drop the suit. I said, all right, that's the best bet for you to do. So I'm good now. So twice.
Let's go.
Yep.
Drop some fire in the chat, man. Drop some fire in the chat.
It works, guys. It works.
Can you go back after them though, Ricardo? Can you go back
after them? Even though I signed that letter, I could go after them. What are they gonna do?
Right.
Oh man. All right, great. And this just goes to show you guys that when you understand what you are capable of, they could attempt to scare you all they want. Stand on business. Stand on business. Why? Because if you know what is required, you see, they win when they test the consumer, and the consumer has no clue what they're supposed to do. And it goes back to the cease and desist scenario that we're talking about, right? In your cease and desist scenario, you send a cease and desist to a debt collector, right? The debt collector did not respond to you. But most people didn't know that by not responding to you, they just open themselves up for several different violations that you're going to include in your lawsuit. The law gives them 30 days to respond, and they must respond. So if they didn't respond, what does that mean for you? Well, first, you can't just say, oh, they didn't respond. No, it's not what you know, it's what you can prove. So let's prove that they have 30 days to respond. Because what if you said, Your Honor, the law says they have 30 days to respond, and then what law says that, Mr. Delevante? What law says they have 30 days to respond? That's a question y'all have to think about, and that's a possible question that you may be asked. So how would you respond to that? How would you respond if you're saying the law says they have to respond in 30 days? But what law says it? Is it something that you can say, or you can show me that I can go look up right now?
Mm-hmm.
I want y'all to think about that for a minute. Well, if I said, Your Honor, the law gives LV&V funding 30 days to respond. They did not. It is a violation of several federal consumer laws. The first law that is violated, Your Honor, is 15 U.S.C. 1681 S28E3, which clearly states that a furnisher, which is what LV&V is, because they are furnishing information to what? A consumer reporting agency. They have a responsibility under 15 U.S.C. 1681 S28E3 that speaks about a time period under 1681 A1A that gives them a 30-day response. That same paragraph states specifically that if the debt cannot be verified as accurate or complete within 30 days, Your Honor, the information must be deleted in accordance with paragraph 5. Paragraph 5 says if the information is not accurate, complete, or verifiable, the information must be deleted. But LV&V funding refused to delete the inaccurate, unverifiable information after 30 days. Which leads us now to 1681 S2A, knowing that they're reporting information that is inaccurate. 1681 S2B, after knowing that the information was inaccurate, they still continued to report it, which only states that they have no regard for the law, which leads us to willful noncompliance, which is why we are here. It is my belief that LV&V funding believes they are above the law. What?
Come on, that's beautiful. Come on.
Like, do y'all just see what you just did in that courtroom?
Powerful.
The
You
rain is
just
8
shut-
o'clock.
You just shut that whole thing down. What
Shut it
possible response could they give? Oh, Your Honor, we responded. Okay, can you provide the certified mail tracking number and a copy of the notice where that notice was sent within that 30-day time period? Crickets?
Right.
Right.
Okay. What do you think is going to happen? Your Honor, I move that you dismiss this case with extreme prejudice.
That's just right.
Not only
Words they used.
Not only am I requesting that you dismiss this case with extreme prejudice, I want to be awarded damages. Damages for court costs, punitive, statutory, plus any other damages the court deemed acceptable. Furthermore, this trauma has traumatized me for months. I can't sleep. I can't eat. My hands shake whenever the phone rings. I don't want to go. I get anxiety going to the mailbox. So now I'm on an emotional roller coaster. I need emotional damages too.
'Cause I got heart palpitations.
Oh my God. They must have with
So
y'all.
being able to articulate yourselves, ladies and gentlemen, is It's what's going to make or break you. It's not enough just, oh, I'm just going to put stuff in AI, but can you actually do the things in your letters that you say you're going to do? Do you know what is required? So as we switch over to the board and we close down the last day, let me make sure I get everything switched over. Right? Sure that everything's good. So as we switch over, and we are halfway through day number 5, we're going to put it all together. Dispute. Everybody seen? Okay. Dispute. Courthouse. There are things that you must know. There are things that you must do. There are things that the other person is supposed to do. And knowing what goes into your disputes is of such importance. All right, so let's talk about the dispute first. Right? In your dispute, we have let's say, there's two ways that, what are the 2 ways that can initiate a round 1 dispute? What 2 possible ways can initiate your round 1? What are the 2 ways that could start or trigger your round 1?
We still talking
Validation.
about
Invalid debt.
All right, invalid debt. How would you know that there's an invalid debt?
a notice. They sent you a notice.
All right, very good. The notice, right?
Yes.
The notice / dawning letter. What's the other way?
A
The item
tax or
shows up on your report.
There you go. Your credit report.
yes.
All right, credit report. These are the 2 possible ways that will trigger your round 1. Your round 1 will be triggered by one of these events. Either you got a notice in the mail, or you pulled your credit report and you see this collection on your credit. Can we all agree that that is the 2 ways that will trigger it?
Yes.
Is
Yes.
there any other way that could trigger it? Your round 1.
Well, if you never looked at your report, but you went to apply for something, and then when they pulled it, they told you you got denied because of something's on your report.
Well, yes, but it still leads back to you accessing the report.
Okay.
So I'd still put that under reporting it or your credit report, right? So after you receive the dawning letter or you pull your credit report, you're going to see the negative information. But you know what? Let me not use negative information, because then somebody's going to say, Darren, we can use the negative information law. Let's not do that. You're going to see the inaccurate information. Now, this inaccurate information, what does this lead to? Inaccurate information is going to lead to what? The dispute letter you're going to send out, right? But before you can send out the dispute letter, there are certain questions that need what? Answers. Yes? Can we all agree?
Yes.
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 All right. So, in order for us to make the correct dispute letter, what are some of the questions now we must know? What do we need to know?
Type of account.
Type of account. And why is this important?
So you know if it's past, it's time barred dead or
Statute of limitation. Very good. What else do we need to know?
When did it? When? What was the first date of delinquency?
Yes, that's a part of it. Because that ties into what? Statute of limitation.
Okay.
Date of delinquency. All right, date of delinquency. All right, what else must we know?
Are we talking about a collection? Or are we talking about in general?
Well, the example that we're using is a collection.
Okay, that's what I thought. Okay. I got you.
We must
Is it-
also know what? When it was placed. Placed on what?
The report.
consumer report.
The report. Why is that important?
Because
For no parking rule.
right.
Parking rule. All right, what else must we know?
Are they even licensed or bonded to collect on the debt?
License, bonded to collect in your state. What else should we know?
Was the debt bought or assigned?
Okay. Bought or assigned. What else?
Are they banned?
Are they on the banned list? Right, so the FTC has a list. FTC has a list of banned debt collectors. All right, we're getting there. What else do we need to know?
Your state's requirement for collecting on debt.
State requirement would come under here. This
Okay.
would be state requirement here. License, bonded, how much? That would come under state requirement. What else do we need to know? Let's see what we got so far. Type of account, which will determine the statute of limitations and the date of delinquency. All right. We need to know when it was placed on the credit report because the no parking rule would apply. We need to know what our state requirements are. The license bonded to collect in the state. Was the debt bought or assigned? Are they on the banned list, right? What else do we need to know? All right. We now need to know what? Information on, well, that would purchase and sale agreement would come under bought or assigned. All right. So we have enough information now to put our round one letter together. So this is called preliminary information, right? These are the things that we need to know to make what? The most accurate dispute letter that we're going to use, or to go into the university, go get the right letter. Is that making sense?
Mm-hmm.
Yes.
All right. So let's start filling in now some numbers. The type of account. So we're gonna figure out now what dispute letter we're going to use. All right. So the type of account, it is a credit card account, right? It's a credit card account. It has a statute of limitations of 3 years, right? The date of delinquency was September of 2021. All right. When was it placed on the credit report? It was placed on the credit report November of 22, right? November of 2022. Licensed and bonded. Yes, they are licensed and bonded. So yes, licensed, bonded, and they're in the state of New York. All right. Was the debt bought or assigned? The alleged debt was assigned. Are they on the banned debt collector list? All right. The answer to that is no. They are not on the banned list. All right. So knowing all of this, how do we proceed? What letter are we going to send for our round one? What letter?
The valid first
The
of all,
validation.
yeah, the validation.
All right, we're going to send a validation.
Okay.
Would this be the best letter to send?
Is this the?
Wait a minute, come on, 1 minute. What year did they put?
You
What?
can send. You
Well,
can send a
no,
no.
there are no parking rules.
You can send a
No
The no
parking.
no
parking.
parking. You can send a no parking.
All right. So we have don't parking. Would that be the best letter to send?
No.
Wow. Which letter, what other letter could we send?
Yes.
Yeah, the no parking is first, I think. Because you can always come back with the 12 CFR, the 1006.334C as a validation.
All right.
We
So,
missed something there.
all right, let me give you some context so you guys can see. All right, look again and tell me what letter would be the best letter to send? What letter?
Oh, wait a minute. Wait a minute. Wait a minute.
What letter would be the best letter to send out?
Hold on, wait a minute. You got the statute of
No
limitation,
parking.
but it's over 3 years.
Yeah,
It's over,
definitely.
it's over 3 years, statute of limitation.
Mm-hmm.
Oh,
No parking.
yeah, they ain't see that.
Cease and desist, right?
Yes. Who said
Yes.
it?
Yes.
April. April.
April. A cease and desist
Yes.
would be the best letter to send. Why? This is now my question. Why? Why would that be the best letter to send?
Because it's past the statute
Yeah,
of limitation.
yeah, they had 3 years
So,
when
so
they
it's
passed it.
past the statute of limitation. So we have now past statute of limitation. What do we know? What do we have working for us now? What do we have that's working in our favor?
The fact that they cannot sue you for the debt.
Time,
Right.
barred, debt. What does that mean? They cannot sue you for nothing. It is barred by time. So if it's barred by time and they cannot sue, what's the only other thing left to do?
Stop our communication. Stop our communication.
So how do we do that? How do we do that? We send out a cease and desist round one dispute. That's what's going to get it a round one. What do we know about a round one cease and desist? What do we know about this letter?
Stop all communication.
That's one part. But it has what?
Three. You only have 3 ways to answer. One
Three
of 3.
possible responses. They
Mhm.
can't sue you. They can't threaten to sue you. So if you send out a cease and desist, can a cease and desist be ignored?
No.
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 No. So they must reply, and the only other response left is what?
Stop all communication.
Which includes what?
The reporting of
Reporting
the
of
correct consumer report.
Booyah. Look at that. Amazing, isn't it?
Yes.
Just off of round one, you completely dominated the dispute process. Did you have to send out an identity theft report?
No.
Did you have to say you're a victim of human trafficking?
No.
No.
Did you have to get a credit repair guru that made all these promises, or all you had to do was read the laws, know your rights, and stand firm on business?
That's all you had to do.
What
No
else do we
guru.
know? If they don't respond, what can you do? Richard, what can you do? If they don't respond, what can you do? I'll give you a hint. 3 words. What's missing?
The S.
Sue. Sue. Round Sue.
Round sue. Sue their asses.
Mm-hmm.
Sue. So what grounds now are we going to sue on? What grounds are we going to sue on, ladies and gentlemen? What grounds? What do we have working for us? What laws?
Cease and desist is one.
All
You
right.
got
So
15.
let's now list. Let's list all the superpowers that we have, right? So the first thing that happened is what? We have statute of limitations working for us, right?
Yeah.
The next thing is we send out a cease and desist, right? The next thing that happened is what? They did not respond, right? We know the law gives them 30 days to respond.
So we're going to have S283.
Right? And they must respond. They must do this. All right. So this is what we know. This is all that happened, correct? We had a debt. It was past the statute of limitation. We send out a cease and desist. So this was round one. Right? We send out a cease and desist. That was round one. They did not respond in 30 days. So here we are about to put our statement of claim together. All right. What laws have been violated? All right.
It's
S2A and B and S283.
Yeah.
Well, let me ask you.
There, we got 15
USC
USC 16
81 R5 first. You're gonna ask for the deletion, right?
Hold on, we're not there yet.
Oh, okay.
Right, we're at CC, right?
That's for cease and
That's a
cease
cease
and
and desist.
desist.
They did not respond. So not responding triggers what? 15 USC 1681 S2 8E3. Right? After 8E3 was activated, we had now a 15 USC 1681I, right? A1A. After 1681I A1A was activated, we have now a 15 USC 1681 I5. After I5 was activated, we now have what? What else do we have working for us? We have 15
S2A and B.
USC 1681 S2A.
A and B.
We have 15 USC 1681 S2B. What else do we have? We have 15 USC 1681N and 15 USC 1680. Is it N or M?
O. 15
And
1681 N
And 1681 O.
and O. Yep.
Wow. And all of this because they did not respond. Are y'all comprehending what's going on?
yes, all the violations.
That's all the violation for a debt collector not responding to your cease and desist. Who knew there were so many violations? Interesting. We could find more. I could put as 15 USC 1681 EB, right? I could do that. We could add 15 USC 1681 EB violation. Why would it be an EB violation?
Well, isn't EB for the CRAs?
And what does EB require for the CRAs? For them to what?
Be accurate, 100% accurate, huh?
For them to report accurate information,
Yeah,
right?
Yeah.
Where does the CRA get the information from?
From the
The
debt collector.
furniture.
From the
From the
furnisher.
furniture.
So if the furnisher gives them inaccurate information, I could argue that it's an EB violation, falsely reporting information to a CRA. That's how I would phrase it. Which then in turn have the CRAs report false information, right? Now, is that a stretch? Yes, it's a stretch. It's definitely a stretch. Because 1681A and B would cover that. But I just wanted to give it more fluff. Does it have teeth? Maybe. But guess what? I can still put it in my statement of claim because they have to what? Admit, deny, or lack information. So if they don't want to deny it, that's their fault because now that makes it what? True. You're alleging things now, aren't you? What else could we put there? I think this is enough. We can leave it. So what's your task? Your task now is to what? Create a statement of claim for a small claim lawsuit. All right, statement of claim for a small claim lawsuit, and you are doing it in the state of New York. So you're going to make a statement of claim for a small claims lawsuit in the state of New York. Take a screenshot off the board. You have, let's see, you have You have 8 minutes to do this. 8 minutes.
To make a statement of claim.
Yep, you are to make a statement of claim right now. So you're going to take a picture of the board. And you are going to make a statement of claim. Everybody, you can go on mute. You have 8 minutes. Boss lady, you with us?
Yep, timer just started.
Set the timer. Let's go. Let's go. You guys are going to think out loud. So, guys, remember, put your mics on mute so we don't hear you thinking out loud, because you will think out loud. All right, let's get it.
All right, guys, time is up. You muted.
All right, time is up. Fingers down, please. All right. So, ladies and gentlemen, you know now that you need to raise your hands and we are going to rate the statement of claims. We will go through the first 4 statement of claim. I will be the 5th person, and then we will go back to the board and then close out for tonight. So, who wants to give it a crack? Let me see what I have been teaching you all week, and let's see if what I've been teaching all week, you guys are ready to put that to the test. Let's go. Let's find out. Let's see. Haiti, I would like one from general admission. I would really like one from general admission. Boss lady, could you do me a favor? Copy the link. Copy this link, the Zoom link, and I want you to drop it in the chat for general admission. Drop it in the
Okay.
I heard something.
No, I said okay. Let's see.
Yeah, drop it in general admission. We're about to close, so I would love to get one. I would love to hear general admission. First come, first serve. All right, guys, remember, raise your hands. Let's go. Who's ready? All right, I see one hand. Remember, guys, I'm only doing 3 from here. 3 from here. 1 is being reserved for general admission, and then me. So if your hand is not up, I'm gonna have to pass. All right. So I got 2. All right, we got 1 more. There's 1 more slot for the VIP brain picker students. Guys, there's only 1 more slot left. First come, first serve. Who's next? Once the next hand goes up, there is no more persons I'll be taking from the VIP brain picker. 5, 4, 3, 2, 1. All right. Nobody else wants to participate. All right. So I'm not taking any more from the group right here. So Haiti, we only have 1 spot reserved for our general admission. They're getting 1 spot, and then I will do mine. So over to you, boss lady.
All right, so Ricardo had his hand up first. So Ricardo, good evening.
All right, all right.
All right, Ricardo, let's hear what you got.
All right, statement of claim, City of New York, Small Claims Court. Plaintiff and his address, defendant and address. The claim is as follows. Plaintiff brings this action against a defendant, a debt collection agency, for multiple violations of the Fair Debt Collection.
So who's the plaintiff? Who's the plaintiff and who's the defendant?
I'm the plaintiff, and the debt collection agency is the defendant.
All right, perfect.
For the multiple violations of Fair Debt Collection Practices Act, 15 U.S.C. 1692, and the Fair Credit Reporting Act, FCRA, 15 U.S.C. 1681. Facts and allegations. 1, the defendant is a debt collector as defined under 15 U.S.C. 1692A6. The plaintiff is a consumer as defined under 15 U.S.C. 1692A3. On or about this date, the defendant attempted to collect a consumer debt from plaintiff and reported information concerning that the alleged debt to 1 or more consumer reported agencies. The defendant engaged in the following unlawful acts in violation of federal law. 15 U.S.C. 1692CC. Continue to communicate with plaintiff after written notice was sent, requesting that all communication cease. 15 U.S.C. 1681EB, failed to follow reasonable procedures to assure maximum possible accuracy of information furnished to consumer reporting agencies. 15 U.S.C. 1681 1A, IA 1A, failed to conduct a reasonable reinvestigation of disputed information within 30 days of notification from a credit bureau. 15 U.S.C. 1681 S2A, furnished inaccurate and unverified information to consumer reporting agencies and failed to update or correct it after learning of its inaccuracy. 15 USC 1681 S2B, after receiving notice of a dispute from a credit reporting agency, failed to conduct a proper investigation, correct the information, and notify all credit bureaus of the results. 15 USC 1681N, willfully failed to comply with the requirements of the Fair Credit Reporting Act. 15 USC 1681O, negligently failed to comply with requirements of the Fair Credit Reporting Act. 15 USC 1685 I5, improperly handled information in a manner inconsistent with the accuracy and privacy provisions of FCRA. Number 5, as a direct result of the defendant's conduct, plaintiff suffered injury, included but not limited to damage to credit reputation, emotional distress, and mental anguish, time and expense incurred in attempting to correct the inaccurate reporting, and denial or increased cost of credit opportunities. The relief requested: plaintiff seeks judgment against defendant as follows: compensatory damages in the amount of $10,000 for emotional distress, credit harm, and related losses; statutory damages as provided by 15 USC 1692 KA, 1681N, 1681O, up to $1,000 per violation; court costs and fees as permitted by law, and any other relief the court deems just and proper. And then the bottom is a verification. I affirm that the foregoing statement of claim is true to the best of my knowledge. Date, signature, and printed name. That's what I got.
All right. On a scale, ladies and gentlemen, of 1 to 10, how much would we rate Ricardo's letter?
I give
On
him
a
an 8.
scale of 1 to 10.
I give about a 7 to an 8.
All right.
give him an
Why?
I give 7 to 8 because I don't think he used. I don't remember hearing any case laws or to use
All
case
right.
laws.
There was no case laws. Very good observation. All right. Who else would like to rate that statement of claim? Right? Seems like we only had one rating. So I would give it around the same. 1, I heard the word credit bureau. 2, I heard no case laws to use or that were used. So I would give you about a 7.5 out of 10.
Got it.
So in my eyes, we're gonna remove the bureau. We're gonna call them what they are. We're gonna go hard after these debt collectors using previous case laws that have won against them to show that, hey, these crooks are doing the exact same thing. So I want to show a history of our history of pattern of behavior to sway things into my ruling. You get what I'm saying?
Got it.
So I'm going to use every strategy possible legally to sway the reader, which in this case would be the judge, in ruling in my favor. All right. So great job, Ricardo. Next up, I got Shari. Shari, talk to me.
Okay. Can you hear me?
Yep, loud and clear.
Okay. United States District Court, Southern District of New York, for the Civil Court of the City of New York, if filing pro se and small claims, choose depending on the amount and relief sought. Shari C. Plaintiff versus LVNV Funding is the defendant. Statement of claim / compliant. Introduction. This is an action for damages and declaratory relief brought pursuant to the Fair Debt Collection Practices Act, FDCPA, 15 USC 1692 ET, and the Fair Credit Reporting Act, FCRA, 15 USC 1681. Plaintiff Shari C. is a natural person and consumer residing in New York City, New York. Defendant LVNV Funding is a debt collection agency and furnisher of credit information. Regularly engage the collection of consumer debts and the reporting of such debt to consumer reporting agencies. 2, jurisdiction and venue. Jurisdiction arises under 15 USC 1681 P and 1692 KD. Venue is proper in this district because the acts and omissions giving rise to the action occurred in New York City and defendant conducts business in his jurisdiction. Factual allegations on or about plaintiff received communications from defendant alleging a debt. Plaintiff timely submitted a written debt validation request to defendant pursuant to 15 U.S.C. 1692 CC, disputing the alleged debt and requesting verification. Defendant failed to respond to the request and continued collection activity, including calls, letters, or credit reporting in violation of the FDCPA. Defendant also reported or continued to report inaccurate information to consumer reporting agencies without proper investigation and violation of the FCRA. Defendant failed to conduct a reasonable investigation after plaintiff dispute violating 15 U.S.C. 1681 S2B. Defendant furnished information it knew or should have known was inaccurate, violating the 15 U.S.C. 16 S2A. Defendants conducted caused plaintiff actual damages, including credit harm, emotional distress, and frustration. Causes of action. Count 1, violation of the Fair Debt Collection Practices Act, 15 U.S.C. 1692. Plaintiff repeats and realleges the preceding paragraphs as it fully set forth herein. Defendant violated the FDCPA, included but not limited to 15 U.S.C. 1692 CC, failing to cease collection until debt validation provided. 15 U.S.C. 1692 E, using false, deceptive, or misleading representation. 15 U.S.C. 1692 F, engaging in unfair or unconscionable means to collect the debt. Count 2, violation of the Fair Credit Reporting Act, 15 U.S.C. 1681. Plaintiff repeats and realleges the preceding paragraphs as it set fully forth herein. Defendant violated the FCRA, included but not limited to 15 U.S.C. 1681 S2A, furnishing inaccurate information. 15 U.S.C. 1681 S2B, failing to investigate after notice of dispute. 15 U.S.C. 1681 EB, failing to ensure maximum possible accuracy of information. 15 U.S.C. 1681 A5, IA5, failing to correct or delete inaccurate information after reinvestigation. Damages. As a direct and proximate result of defendant's conduct, plaintiff suffered actual damages under 15 U.S.C. 1681 NA 1A and 1692 K A1. Statutory damages of 15 U.S.C. 1681 N A1B and 1692 K A2A, costs and reasonable attorney fees if applicable. Punitive damages under 15 U.S.C. 1681 N A2. Prayer for relief. Wherefore, plaintiff respectfully requests that this court enter judgment in her favor and against defendant as follows: actual damages, statutory damages, punitive damages where applicable, costs and reasonable attorney fees, and any other relief the court deems just and proper. Respectfully submitted.
All right, very, very good. All right, on a scale of 1 to 10, how much would you give Shari for that statement of claim?
This time I'm giving about an 8.5 to her. Now I still didn't hear any case laws.
Yeah, I forgot
8.5. Yeah, I would agree.
The case law.
I would agree. 8.5. And the reason why you got an 8.5 from me is I love the fact that you not only brought in the 1681 and the 1681 O, you also brought in the 1692 K, which is the civil liability section of the FDCPA. So I thought that was really, really good. All right. So yeah, you definitely got an 8.5. You're moving up, Shari. You're moving up.
Progress.
I remember the first time you made a statement of claim. It was like a 4. Does anyone remember?
Yeah, it sucked. I don't even.
Who remember it? It was like a 4 when Shari made us. Her first statement of claim was a 4.
Yeah,
Does
I
anybody remember?
I remember.
Oh yeah, I remember. She just jumped. She just doubled her points.
Double and a half.
Fast. She really
I
did.
take that. Thank y'all. Thank you.
Like that is growth. That is improvement. From a 4 to an 8.5 out of 10?
Yes.
Wow. Yeah. Is there anyone here from general admission that have your statement of claim that you would like to present? Is there anyone joined us from general admission?
I seen two people join. I don't know if they stood on or if they fell off.
I'm
Do you-
here. My
Uh,
name's
I
Tyra
hear
Walker.
I hear somebody. Do you have your statement of claim ready?
Yes, Tyra Walker.
All right, raise your hand for me, Miss Walker.
Yeah, she's under Samsung.
Okay, let
Samsung.
me. I
So
don't
go
know
to the
if
bottom
I.
of your screen. You're gonna
Okay.
see raise hand or the react button. It should say raise hand somewhere there.
Okay. I'm sorry. Hmm.
At the bottom of your screen, you're gonna see react.
Okay,
Oh,
reactions.
raise hand now. Look for the part that
Okay.
says raise hand.
Raise hand.
Boop.
Okay.
There you go. Shout
Perfect.
out to Samsung in the building. All right. So this is the rules, right? We got the scenario. We were to make a statement of claim. So now you're going to present your statement of claim, and now we are going to rate it on a scale of 1 to 10. Are you ready, Miss Walker?
I'm ready.
You ready? All right,
Yeah.
boss lady. She's ready. Let's go.
Okay, plaintiff Tyra Walker, by way of complaint against defendant debt collector, alleges as follows. Plaintiff is a resident of the county, the state of New York. Defendant is engaged in the business of collecting consumer debts within New York and is therefore subject to the Federal Fair Debt Collection Practices Act 15 USC 1692 and the Fair Credit Reporting 15 USC 1681. At all relevant times, the debt at issue was a consumer credit transaction under New York law, meaning credit extended to an individual for personal, family, or household purposes. At a time more than 3 years prior to the date of this complaint, plaintiff incurred a consumer debt to personal, family, or household purposes. The debt has been inactive for more than 3 years, exceeding the statute of limitations applicable to consumer credit transactions under New York law, CPLR 214 on I don't know what date. Plaintiff sent a written cease and desist letter to defendant demanding that all collection efforts cease. Despite receipt of the letter, defendant continued collection activity, including repeated phone calls, letters, threats of lawsuits, and reporting the debt to credit reporting agencies without validating the debt or disclosing that it may be time barred. Defendant misrepresented the legal enforceability of the debt and engaged in deceptive practices in violation of the FDCPA. Defendant may also have violated the FCRA by furnishing inaccurate information regarding the debt to credit reporting agencies and failing to correct it after plaintiff's disputes. Violation of FDCPA. A debt collector may not use any false, deceptive, or misleading. Um, oh my goodness, I'm sorry.
It's all right.
Or misleading representation or means in connection with the collection of any date. McMahon and LVN Funding
Okay.
LLC attempting to collect on a time board debt is a violation of 1692. Violation of FCRA, defendant may have violated. Furnishers must follow reasonable practices to assume maximum possible accuracy. Cushman versus TransUnion Corporation, furnishers and agencies must investigate and correct disputed information and action arising out of consumer credit transaction must be commenced within 3 years as a direct and proximate result of defendant's unlawful conduct. Plaintiff has suffered emotional distress, anxiety, sleepless nights, embarrassment, and stress caused by repeated harassing communications, financial harm, damage to credit score, and plaintiff also seeks statutory damages under 15 USC 1692K A2A up to $1,000 and cost of action. Wherefore, plaintiff respectfully requests judgment against defendant for actual damages in amount to be determined for emotional and financial harm, statutory damages under FDCPA 15 USC 1692K and FCRA 15 USC 1681N and 16810, court costs and reasonable attorney fees, order directing defendant to cease all collection efforts on the time barred debt. Any other relief this court deems just and proper.
Woo-hoo-hoo. Whoa, 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 whoa.
Nice.
Samsung, why did you get a general admission ticket again?
Nice.
That
I'm
was
broke.
beautiful.
I wanted to be in it, but I'm working on it. So
That was amazing. Guys, on a scale of 1 to 10, how would you rate that statement of claim?
9
She got that 10. She got the 10.
Yeah, definitely a
She
10.
I was at a
Yeah.
9.5.
That's what I'm
Yeah.
thinking. She got the 10.
Nice.
I was torn between a 9 and a 9.5.
Yeah.
Right.
why?
Nice.
So my only issue with it is that strength. You have the right stuff, but to me, it sounded a little bit passive.
Okay.
But that's just me. Like, I like to punch people in the throat. So I'm aggressive, right? But your style of communication and your style of writing could match your personality, and there's nothing wrong with that. You had all the points. You identified the plaintiff. You identified the defendant. You identified the laws, the statute of limitation, time barred. You used time barred case laws. You use FDCPA civil liability, FCRA civil liability. You hit all the points. The only thing that was missing for me was strength. That's it.
Lorraine, can I answer your question?
Yes, go ahead.
What would you, based so we can learn from hers and you, what would you have switched on hers? Just when you say strength, what word is this, and where would you have put it?
Well, when I say strength, would you like to hear my statement of claim?
Oh, I know yes, I know it's coming.
Come on.
So if you hear mine now, you can now determine what I
Okay.
mean by strength.
I
But
got you.
that was good. I put
was
you at a
great.
solid 9.5.
It was great. It was definitely great.
It was amazing.
I've been watching you
We
for
enjoyed it.
years.
It's definitely
Thank you
showing.
all.
It is
Good
definitely
job. Good
showing.
job.
All right, let's get it now, Daraine. Whew. I hope I can beat this 9.5. You just set the bar real high, Miss Walker. Wow.
He ain't gonna get it.
And y'all better rate me honestly too. If mine is not a 10, y'all need to let me know, all right? Not because I'm the coach. Coaches make mistake too, especially drinking 3 shots of Don Julio. You never know what my fingers might type.
Wait.
All right. Y'all ready?
Ready.
Yeah.
All right,
Ready.
let's get it. New York City Civil Court, small claims, right? Amount claimed, I'm going straight for the maximum, 10,000. Plaintiff, Daraine De Levante. Defendant, LV&V Funding. Court location, Bronx, Queens, Brooklyn, whichever county you reside in, right? Nature of claim. I am suing LV&V Funding, LLC, a debt collector for 1, attempting to collect a time-barred debt in violation of New York law and federal law, furnishing inaccurate and misleading information on my credit report in violation of the Fair Credit Reporting Act, failing to respond to my cease and desist and validation request under the Fair Debt Collection Practices Act, continuing to report and collect on a debt that is past the statute of limitations in New York, which is 3 years under CPLR Section 214I. Willfully ignoring my rights as a consumer, causing damages to my credit report, emotional distress, and financial harm. Facts. The alleged debt went delinquent before November 2019, over 3 years ago. In November 2022, LVNV Funding placed this debt on my credit report, falsely reporting it as active and delinquent. I sent a cease and desist letter person 15 USC 1692 CC and a validation request under 15 USC 1692 GB. LVNV Funding never responded. More than 30 days had passed with no verification, no communication, and no correction. 15 USC 1681 S28E3 and 15 USC 1681 I A1A, they are required to respond, investigate, and correct the information. They willfully and negligently violated federal laws and continued reporting this false expired debt. This illegal conduct has harmed my credit score, caused me financial losses, and emotional distress. Case law and legal support. Hinkle versus Midland. Debt collectors cannot report inaccurate information or fail to conduct real investigations. Johnson versus LV&V. Time-barred debts cannot be collected or reported without proper notice and compliance. Chauncey versus Bank of America. Failure to cease collection after dispute violates the FDCPA. Jacobson versus Healthcare Financial. Debt collectors are strictly liable for false or misleading practices in New York. Cushman versus TransUnion. CRAs and furnishers must conduct meaningful investigation and correct errors. Violated statutes. 15 USC 1681 S2A, S2B, 1681 S28E3, failure to reinvestigate or respond. 15 USC 1681 IA1A, 15 USC 1681 IA5, failure to correct inaccurate reporting. 15 USC 1692 CC, 15 USC 1692E, 1692F, continued after cease and desist. 15 USC 1681N, 1681O, entitles me to statutory, actual, and punitive damages. Amount demanded, I'm seeking the maximum statutory damages permitted under this court's jurisdiction for intentional and willful violations of the FCRA and FDCPA, false credit reporting, emotional distress, and reputational damage, failure to investigate, failure to respond to dispute and cease and desist letter, collection activity on a debt barred by law, requested outcome. I respectfully request the court to award me $10,000 in damages, order LVNV Funding to delete the inaccurate trade line from all consumer reporting agencies, issue any additional relief the court finds just and proper under New York and federal law. Signed, Lorraine De Levante. How would you rate that?
You got a 20.
No, he didn't. I'm gonna be the troll today.
All right. What was missing, boss lady?
One, I felt like you could have tightened up the language for more professionalism. You said, this illegal conduct has harmed my credit score. That's juvenile.
Remember
We should be
now,
using better language.
I'm not using my own AI. I'm using a neutral
So
AI.
I'm grading. And then usually one thing that I notice everyone missing is like no one included exhibit references. You go into court, like shouldn't you include your exhibits? Exhibit A, here's a credit report showing LV funding entry. Exhibit B, you've always add exhibits every time you file during. That's one thing I
could
know
use
everybody was
exhibits,
missing.
but the nature of this dispute is a cease and desist that failed to respond. Could we use exhibits? The answer is absolutely yes. Do we need to? No, because we're the plaintiff and we're alleging. They have to defend.
Well, I mean, usually we'll put the exhibit B, like the season says, and validation letter sent, the proof of delivery, certified mail with the return seat. So like, hey, we already sent out the first one. Like
that is not required because we are alleging. We are putting out allegations. They now have to say either accept or deny. right?
Okay.
So let me give you an example now. So let's say normally when we're the defendant, we're defending, which means now we have to bring all the proof, right? But when you're the plaintiff, I'm alleging. So if any of my allegations you did not deny, it means my allegation is true.
Okay.
So if when I put the statement of claim in and you respond, that's when now I'm going to bring out the big guns to further shut you down. But as of right now, I'm feeling you out.
Got it.
But
Right,
go
because
ahead.
you're the plaintiff. You want them to bring whatever evidence they
Correct.
have.
If I went to civil, I could say LV&V, I'm suing you for $1 million. They now have to defend. Because I am the plaintiff, it doesn't mean everything I'm saying has to be true. I'm alleging all of this. I could be even making up lies in my allegations. The defendant now has to prove and deny or dismiss all the claims that I have or all the allegations that I have. Whatever is not denied is presumed true. Boss lady?
Okay, so I guess you could get an 8.8. I mean, yeah. You get 9.8. You're not getting 20. You're not getting 10.
All right, I
Durang,
see we have a hand up.
Oh, no.
Hey, Durain. Hey, Durain, this is Benjamin Clark. How are you doing?
What's going on, Benjamin?
Nothing much. Hey, I have a question to kind of take it a step further.
All right, let's get it.
Since you are the plaintiff in this case, how would you get past, let's say the defendant comes back and says they file a motion to dismiss for what's that called? It's that federal rule of civil procedure. They try to get it kicked out. Could they come back with something like that?
They could, but they would have to state grounds on why they would want it dismissed. So let's say they're saying that I lack standing, right? What do I lack standing on? So now it goes to, it's not what you know, it's what you can prove. So let's say they responded and they're saying that in my statement of claim, they did respond. Because remember now, the burden of proof is never on the consumer. The burden of proof is always on the institution, the CRA, or the furnisher. So now if they responded, so give me one of the responses that you would give so we could do devil's advocate and play a little tennis.
Sure. Federal Rule of Civil Procedure, I think it's 12B or something like that. I could be wrong on that, though.
And what does it state? I don't have all the laws memorized. I wish I did, but I don't.
That failure to state a claim upon which relief can be granted. How do you get past that part? Yeah.
So if LV&V says failure to state claim on which relief can be granted, well, they're saying that I failed to state claim, but they still didn't respond to my statement of claim. So one, I'm going to reiterate the fact that they failed to respond to the statement of claim, and whatever they didn't respond to, they admitted to. That's one. And then two, it is up to me now to prove the things that I'm saying. So what Haiti had mentioned earlier now comes in effect, right? So now I'm going to draw for Exhibit A. Exhibit A would be the credit report. I'm going to pull the credit report and I'm going to show the entry that was made, right? I'm going to also show when the account was open, when the account went delinquent. I'm going to have a printout now of the New York State statute of limitation and what it states. Then we're going to establish timelines, because the first thing we establish that the debt is past the statute of limitations. So I would now, in my research, find other statutes of limitation case laws to use now in my response to them. Does that make sense?
Makes perfect sense. I was trying to see how it would go, like a back and forth, because it sounds like you just didn't show your cards immediately.
Not yet.
Yes.
I don't like showing my whole hand before I know what, because what if this statement of claim prompted them to say, all right, we're going to negotiate a settlement? I just saved myself some work. But if you're going to make me work, best believe I'm going to draw for everything I have now.
Absolutely.
If you're going to put me to work, I'm going to put you to work as well. So now I'm going to go for credit reports. I'm going to go for damages. I'm going to go for any denial letters that I have. I'm going to go for reputational damages. I'm going to go for defamation of character, because all of these things can be proven. Your credit report also shows your what? Your characteristics, your character. If someone damages your character, what's the definition of that? What's the word they use for that? Defamation. If it's written like what's on the credit report, it's written information. Now we're talking libel defamation, right? So now I'm going for everything. I'm bringing everything now to the front line. There's no more holding back. If you're going to make me work, best believe I am going for it all.
Hey, thank you so much for that dialogue going back and forth. I really appreciate
You're
that.
absolutely welcome. And I'm actually glad I like playing tennis, because now you brought up something else. Okay, so now they thought, oh, Doreen, you have no case, you have no grounds, you stated no claim. Really? So this is where, and remember now, guys, you don't have to sit down and bust your brain with all of this stuff. It's one of the cool things that AI can do. AI can bust its brain for you. All you need to do is program it with the right prompts. Right? So we program it with the right prompts. What are the key things? So let's go over to the board. I like this part. Before we close out for tonight, this is a good way to close out. It's actually a great way to close out. Oh, there we go. All right. So if they're going to state, so a response would be failure to state claim. Oh, they love using this. They love using this. Right? The first thing I'm going to write down in my notes is that defendant failed to respond to all paragraphs in statement of claim, right? So I'm going to identify what they didn't respond to, if they responded to anything. And then I'm going to use the doctrine of silence is me and this word, I swear to God, me and this word, can someone spell acquiescence for me, please? Silence is, I think it's A-Q.
You said spell what?
Acquiescence. Silence is acquiescence. It's like a doctrine. If you don't, what's the word I want to use? If you don't challenge, if you don't deny, then you're admitting with your silence. That's kind of what it means. Acquiescence. This word might be spelled wrong. I never told y'all I'm a spelling bee champion. All right. I'm going to use the doctrine silence is acquiescence, right? Next, I am going to go for defamation of character, right? I'm going to go libel, right? Because your consumer report is written information. Next, I am going to go for credit reports. I'm going to show. So what does my credit report show? Can anyone tell me what I'm going to extract from my credit report? What can your credit report show? Account info. It can show the account. It can show open date. Right?
Yes.
It can show open date.
Balance.
No, balance wouldn't count here. We're not looking for balance. It's going to show open. But most importantly, it's going to show what? Delinquency.
Date of last payment.
Yes, delinquency.
I got that word for you if you want me to spell it for you.
Yeah, you got it?
Yes.
All right, let's get this out. Go ahead.
Is ACQUIESC
S?
S
Oh, wow. All right, so ES.
IES C
Wait, wait,
E
wait. Hold up, hold up, hold up. We have ACQUIES.
C as in cat,
Okay, okay, okay. See?
ENCE.
Y'all see why I'm in this word fight every time?
Yeah, I see why. It's too much.
Like it's so many of the same words, I don't remember where to put them. Right? So the most important thing we're using the credit report to confirm for us is account opening, account delinquency. So that establishes what? A timeline. And the timeline proves our what? Statute of limitation.
Limitations. Yep.
Defendant failed to respond to all prior. So no, I didn't put statute of limitation there. So this proves our statute of limitation time bar. Right? So right here, my statement of statement of claim is going to be based on this. This is the foundation of my lawsuit. All the other stuff I'm adding there as oomph. They can deny all the other stuff they want, but I know this cannot be denied. They cannot deny this part because that part I can prove, and the state of New York has a law that supports a debt barred by time. So I know even if I have 15 paragraphs and they deny 14, I know I still got the most important one left, which is the statute of limitations. Now, right? So I'm pulling credit reports. I'm going to put a copy of the dispute, right? Round one, cease and desist. So boss lady, this is when that cease and desist will come in, right? And what else am I going to add to this? Copy of the certified mail, right? Certified mail, green return receipt, right? Because we want to show that it was delivered when it was delivered, the 30 days that passed, because now it's not what you know anymore, Doreen. It's what you can prove. Is everybody following?
Yes.
Yes, no, maybe
Yes.
so.
Yes, yes.
All right. So now, I'm going to go deeper. So they're asking me for a copy of my dispute. I'm going to present that copy of dispute, round one, cease and desist, copy of the certified mail green return receipt. Let's see what else we're missing here. All right. Their response, their lack of response. Lack of response. So if I have the fact that they did not respond, which is the S28E3 violation, 1681I, 1681I, A1A, right? This is the 30 days. So this is the 30-day timeline. So everything that I do now, and I say, I'm going to tie the corresponding law with it. Does that make sense? So if there's a statement that I'm going to make, that statement that I'm now going to make is going to be accompanied by the law that was broken or violated to support, further support what I'm saying. If what I'm saying requires a case law, like let's say that the information is still being reported on my credit report. So let's say that I'm going to use that in there, right? So let's say I'm going to say 7. Defendant still reports inaccurate info to CRA, right? How am I going to prove that? How am I going to prove that the defendant is still reporting inaccurate information to a CRA? How am I going to prove that?
For your credit report.
Yeah, copy of my credit report, right? So a copy of my credit report is going to prove this. And now I'm going to use a what? I'm going to use supporting case laws like a Hinkle versus Midland. And I'm going to state that what? They violated the FCRA by reporting a debt that cannot be validated. How are you going to validate a time bar debt as accurate? How?
You can't.
You cannot. You can't. Are y'all following what I'm saying? Now,
Yes.
I'm going to
Yes.
talk
I got a
about the
question.
fact that they did not respond to the cease and desist, right? So I'm going to bring up the 1692 CC, and I'm going to bring up what? Case laws that speak about that. And I'm also going to respond to the fact that it required one of three responses, which LVNV failed to do.
So I have a question.
Who has a question?
Stephen McMullen.
Hold on. Let me see what's popping. All right, go ahead.
So, like you were saying earlier, if you sent them a dispute letter with 5 claims and they didn't address all 5, they only addressed 2, but they agreed that the information is accurate, are they basically saying, because I told them I didn't receive a dispute letter, and they said all they replied back with is the account's accurate and is reporting accurate?
So that would mean that they responded.
Right, but did they respond to my claim? Because I had 5 different claims. One was I didn't just receive the dispute or the disposition letter, the pre-sale letter, or the post-sale letter. Then 2 other ones were reporting false information. They responded that the
Pre-sale,
false information.
post-sale, that would be repossession. That's a bit different than what we are. This is for a
Right.
credit card debt.
No, I was just asking if they don't reply back to all 5 claims, though.
No, so in your statement of claims, right? You see, in your statement of claims, if there is 100 paragraphs in there, right? All the paragraphs need to be responded to. Whatever you don't respond to, you admit to.
Sweet, that's all I was asking. Yeah, because they basically are admitting that I didn't receive my letters.
Whatever is not, and this is why a lot of people get a default judgment against them, because they're going to write paragraphs and they're going to write statements claiming that they were sick, they were in the hospital. But, beloved, you did not respond correctly to the statement of claim. Your answers were not correct to the statement of claim. Therefore, while they sympathize with you, you did not respond. And by not admitting or denying, or you lack sufficient information, so you deny, I'm going to ask for a default judgment if I'm the plaintiff.
Sweet, thank you. That's all I need to know.
Yeah, I'm sorry that you went through that, but that's not how you respond to a summons. That's not how you respond to a statement of claims. That's not how you do it.
Yeah, they never summons me to court. They just basically repossessed my vehicle. I sent a dispute to them directly, letting them know that I didn't receive any of the notices, showed them proof I didn't receive the notices, and all they responded back was, well, it's accurate.
Well, now you have a lot. Were you in class yesterday? I think we covered repossession yesterday.
Oh, I missed yesterday's class.
Oh, you need to get the replay. You need to get
I watch the
yesterday's
videos
replay.
every day, so yeah, I'm gonna definitely
Because
watch
yesterday's replay, what we did was, and I know we're over time, guys, and man, this thing gets so good, you don't even want to leave, right? I wish I had,
know. I
wish
need
I
more
had
time.
all week with y'all, but I don't, right? So yesterday's class, right? What was the? Does anybody remember the scenario? You were at home, came from work, they took the car, they opened the gate, forced open the garage. What's like? We went so detailed in repossession yesterday. It was next level, right? It was next level. That repossession scenario yesterday, oh, it was so good, so good. So yeah. So take some pictures. There's a lot more that I could come up with, guys, to really go crazy. But we're at the end of class and it's Friday. Y'all got stuff to do. I got stuff to do. I've been up since 5 this morning. I got stuff to do. I wish I could give you all of it today, but I can't. There's not enough time. And I know there's a lot of you here that would love to continue learning. So, for those of you that would love to continue learning, and I think I don't have to convince you, I think you've come to the logical conclusion that this is where you need to be. And for those of you that came to that conclusion, guys, if I have to lift you up and pull you across the field and throw you across my neck during the sprint drag carry, I'm not. I got too much stuff to do, beloved. I am not in the business of pushing anybody across the finishing line. I am going to finish with the ones who want to finish with me. I'm telling you, because a mind convinced against its will is of the same opinion still. So if you're not ready to join, you're not ready, and you will always use the excuse of, I'm not ready. I'm going to sit with my bad credit. And if you want to do that, that is your prerogative. I'm not going to say you're right. I'm not going to say you're wrong, but you do know that where you need to be is here. And if you think that where you need to be is here with us, going through these type of training, getting these type of scenarios, I promise you, the things you will be able to do will be next level. I'm talking about learning how to dispute and dispute correctly. How do I get the right dispute letter that I need? Well, you have to go through a process of triaging what the current situation is. You're not going to know what you need until you answer a few questions. There's some questions you need to answer. And based on those answers, you now will see what your round one will look like, right? And from your round one, what am I supposed to get back? What are they supposed to respond with? If they don't respond with what is required, what do I do next? And from that, okay, do I have enough supporting documents now to go file a small claim lawsuit? Right? Every step of the way, ladies and gentlemen, I do not need you to convince. I don't need to convince you that this is the best decision for you. All right. I'm gonna enjoy my Don Julio for the rest of the night, because whether you join our beautiful community and take this game next level or not, I'm still gonna be drinking Don Julio on the rocks. I am. Right? I'm still going to fly to New York next week. I'm still going to Jamaica for 3 months next month. I'm still going to do these things, whether you decide to fix your credit or not. I'm still going to learn how to trade and make thousands of dollars per week. I am. So if you want to sit on your hands, it is your prerogative. A mind convinced against its will is of the same opinion still. If you believe you can, you can. I can do all things. As a man thinketh in his heart, so is he. So if you believe you're a winner, guess what? You're a winner. But if you believe you're a loser, you are a loser. If you believe that you can't afford it, then guess what? You cannot. If you believe you can, you can. Because don't we all buy things we can't afford? I'm sure some of us owns a car. You didn't buy the car cash. Some of you got a house. You didn't buy the house cash. There's a lot of things we buy that we can't afford, but things that can change your life should be priority in the things that you want to do, in the goals that you want to accomplish. And it's important, ladies and gentlemen, that you put you first. Guys, I told y'all this at the beginning of the year. I am very selfish this year. It is me, me, me. Because if I can't help me, how am I going to help anybody else? Like, I'm going to help somebody while learning how to swim. Then both of us are going to drown. No, 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 no. I love me more. I love you. I do. But I don't know how to swim it. I am not going to attempt to save you. Because chances are, if I can't swim and you can't swim, both of us is going down. I'm not going with you. I'm telling you the truth. I am not. I am so selfish about me right now. I cannot help nobody until I help me. How are you going to help people fix their credit if you're not going to fix your own? How are you going to be financially free and set your family off on generational wealth if you are still sitting down and not deciding that today is the day I take action on my own life, on my own credit? It is my credit, so it's my responsibility. Your current financial situation, your current credit situation does not define your financial reality. The choice is yours, ladies and gentlemen. It's always been yours. You can either be a victim like you've been, or you could step up to the plate and really test somebody's gangster. You know, during this week, I heard Shari, I heard Mikey, I heard Kenny. You know what they said? I wish they would. I wish a debt collector would put something on my credit. That's a bold statement. That's a bold statement. I wish they would put some negative stuff on my credit. Like, can you imagine? Can you just imagine someone walking around saying, all you debt collectors, come put some stuff on my credit? There's people that can't even sleep because they have stuff on their credit. They're anxious. They have anxiety because they're being sued by a debt collector. And you have people walking around saying, I wish they would. It's quite obvious that the ones that are asking for it to be on their credit know some things that the ones that don't ask for it know, right? They know something y'all don't know yet. And that's the thing. That's the secret. That's the power, the control. That is the mental fortitude. That's the cojones that you're going to have. Yes, very big balls. Asking somebody to test your whole gangster. I wish a debt collector would. I wish they would. Try me. Try me. I wish you would. This type of confidence, this level of confidence comes not only from information, because a lot of people know things and they're not doing anything with it. Guys, we ran a few scenarios this week, and y'all are getting 8.5, 7, 9, 10 out of 10. Not only for your dispute letters, for your statement of claims. That is powerful. So if you're watching this and you're being sued by a debt collector, if you're watching this and there's a collection on your credit report, if you're watching this and you have any negative item like late payments, charge off, student loans, repossessions, bankruptcies, if you're watching this and your credit needs work, this is the place for you to be. There's nowhere else for you to be. I mean, you could go over Metro 2. You could. Absolutely. Go ahead. But I've never seen or heard of a Metro 2 lawsuit where somebody got paid. I've never seen one. Maybe they're out there, maybe. But because I'm biased to consumer law, I'm not going to waste my precious time to go look for it. It could be out there. But I know for a fact there is more consumer law, multi-million-dollar lawsuits than anything else. I know that. Obviously, there's a power here at work, and it is your responsibility to learn how to harness this power. With great powers come great responsibilities. That is it for day 5. I wish I could stay here longer with y'all, but I don't. I can't. I got things to do. I got to go study. I got to go speak to my son. I got one more shot of Don Julio that I need to go finish. I got things to do. All right. So class will be on Monday. Class will be on Tuesday. And for those of you in the connoisseur, for those of you in the university, guys, I am telling you, we are turning the next chapter on how credit repair is done. We are the pioneers. We are first to do it. Anybody else they're following, we are the ones that's going to dominate this space. And with the use of AI, our credit repair, consumer law, and case law strategies will be next level. Boss lady, please drop the link so anyone drop it on the Zoom, on the YouTube, in the chats, in the school groups, inside of the Facebook groups. If you're hearing the sound of my voice, the time is now. Not tomorrow, not next week. It's now o'clock. Stop sleeping on your dreams. You've been asleep long enough. It's time to wake up. Grab a debt collector by the throat and punch him in the goddamn mouth. It's been real, ladies and gentlemen. From your boy, Durain De Levante, I will see you for class on Monday. It's truly been an amazing week. I will see you guys on Monday.
Thank you.
Let's go.
Thank
Peace.
you.
Yeah, thank you.
Appreciate it.
Enjoyed
Most
this.
definitely.
Thank
Most
you.
definitely.